sort of.
All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. I am Judge Furuya. To my right is Judge Morse. To my left is Judge Weinsweig. And we are here for oral argument in our case number CV23-0686. And I'm going to butcher this name. Casaus or Casaus?
I say Casaus, Your Honor.
Casaus versus State. As you know, we record and live stream these proceedings, so please give your name and the name of your client before you begin. You have a maximum of 20 minutes per side, although you are not required to use all of that time. We do require you to keep track of your own time, which is there in the podium, and any remaining minutes that you would like to reserve are your responsibility. Please keep in mind that we have read the briefing, studied the record, and discussed the case in conference. And with that, Mr. Abney, you may begin.
May it please the Court, my name is David Abney. I'm here representing the plaintiff's appellants. I was here at the last argument, and I was sitting there listening to my colleague across the aisle tear holes in my case, and I thought to myself, I got another case coming up. What is this case about? And for the life of me, I couldn't even remember what it was about, but I remember now. It's one of these unfortunate cross-median events on a highway in the middle of nowhere. The oncoming driver falls asleep, crosses over, and causes a terrible crash. The point of the lawsuit against the state was that there should have been median barriers to prevent anything happening, whatever the reason was that a person would be trying to cross over or the vehicle was aiming to cross over. That's the point of the case. And instead, the case turned out to be a case about a marijuana-impaired, supposedly, driver who caused this whole thing. He had smoked a blunt. He had marijuana junk in his car. He was supposedly impaired by marijuana, although there was never any evidence of actual impairment. No expert ever said he was actually impaired at the time that this happened.
Didn't the initial test positive for marijuana metabolites?
Well, there were two blood draws. One at 6:51 p.m., which was absolutely negative. And
Was
then
that the one that was tested 6 months later?
No, I don't know. It was tested at the time. It came up absolutely negative. I don't recall anything about a 6 month later test. But then there was another blood draw. So the blood draw at 6:51, 0, negative, absolutely. And then one at 9:09 p.m. that had this level of the metabolite in the body. But even with a level of metabolite in the body, it doesn't prove impairment.
But can't the jury make that inference to reach back to the last argument?
Could a jury infer from no?
I mean, I shouldn't bring the argument, but I will here. You had marijuana in 3 places in that car, right?
Right. But you've got
And that's not relevant?
No. You've got the government's own expert that says, I cannot tell you with a reasonable probability that there's impairment. I can say, it's possible.
Wait. Okay,
right?
so
Smith.
Hold on. We have evidence that marijuana is in his glove compartment. Evidence that the marijuana is throughout the car.
Right.
Evidence that there was marijuana or at least green leafy substance on his face.
Yes.
And his own statement that he had smoked marijuana.
Yes.
And that's not enough for a jury to say, hey, he probably is under the influence of marijuana.
It's enough for the jury to say he's a marijuana user, and if they don't like marijuana users, it's enough for the jury to say we don't like them. And that's all that it's good for, because you have to have expert testimony that any particular level of the metabolite in the body has caused impairment. Their own expert, Smith, says it's correct that it's not his opinion that impairment from marijuana had caused Behar's sleepiness and loss of control, merely that such a thing could have been the case. And as we discussed at the last argument, and as you go back to Binkendorf and all these other cases involving experts, possibilities when you are the proponent, not enough. possibility when you're defending for some reason you get away with that. But if you're an expert and you're trying to prove a proposition, it has to be by probability, to a reasonable degree of certainty in your field of expertise. And Smith backed away from that like it was last day's
And
garbage.
I agree with you on terms of an expert opinion, yes, but we're talking about a fact that the jury is asked to find.
Well, you're talking about some sort of reasonable inference of impairment, simply from the fact that there's this marijuana stuff around. That's no good. Even in the Arizona Supreme Court, it says that's no good in the Harris case. There's no scientific evidence, there's no scientific consensus that a particular level of THC in the body is actually going to cause impairment. And
So if it did test positive at any level, it's still not enough because there's no conclusive testing clinically that it would impair?
Right. There is no scientific consensus that it's going to be causing impairment. And if so, what kind of impairment?
Let me ask you just a quick question. Are you making the argument that Juror 34, that it was reversible error, that he should have been struck? Or is that just an argument as part of the marijuana, that some people don't like marijuana?
Well, it's part of it. It's the main thing about the jury vetting. What do they call it? Voir dire? Yeah, voir dire. The voir dire process was the jury was at that point introduced to the marijuana problem in the case, and reintroduced in the opening statements, and reintroduced over and over during the course of the trial from the testimony, and then the final kickoff in the closing argument.
Objections during all these parts?
Yeah, it was a motion in limine to prevent all this stuff from coming in. It was denied. I mean, that preserves the error. And it also gives you the opportunity to try to pull the sting, which is what the plaintiff's counsel did. They did the best they could to try to defuse this potentially disastrous situation. And I think it turned out to be, I submit to the court, it turned out to be a disaster, because by the end of the case, the government had originally said that Casaus was at fault. And then in closing argument, they said, no, whatever her speed was, it wasn't a cause of the crash. So even if Cynthia was negligent, that's not enough to put fault on her. If she was negligent for speeding, it still has to be a cause of the crash, and it wasn't. And that's what they told the jury. So the jury winds up at the end with, who are you going to blame, Behar or the state? There's nobody else to blame. You got to portion 100% fault.
But that's what the jury has to do, though, right? I mean, kind of at a fundamental level, you got to trial on this one. And
Sure.
You get to argue that it's a lack of barriers, and the state gets to argue
Behar.
And so how do we set this verdict aside? I don't understand.
There's a huge difference here from saying Behar's at fault because he's a negligent, reckless driver. He fell asleep. He shouldn't have fallen asleep. Terrible thing to do. He's wholly at fault.
And does
completely
fit within that? I mean,
no, that taints everything. It's not just that he's a negligent driver and he fell asleep. He is a drug impaired. He's a druggie. He's a marijuana user. He's a bad person. Bad. And we're going to talk about marijuana every single chance we get, because we know for some people, including the people on this jury panel, marijuana is a red flag. It causes them great concern.
Well, there's probably some people that like marijuana, and they might be on the jury as well.
Yeah, well, yes,
So
Your
why
Honor.
are we supposed to infer that jury 34's opinion pervaded the entire jury?
Well, you're talking about a rural jury. Maybe if they like it or don't like it, maybe they grow it in the backyard. I don't know. But there's a lot of public shame. There's a lot of still attached to marijuana, especially in certain
would you
communities.
agree that if there was some evidence that this state had presented that said there's a link between drowsiness and marijuana, for example, that the evidence should have come in?
If you had an expert to really tie it in tight, sure. But there was no expert like that. The government's expert ran away from this. He said, no, I'm not going to say that. I'm going to say it's possible. That's all he was willing to say. It's not just that they can blame Behar. That's okay. He's the guy who crossed the median. So it's all his fault. It's too bad. It's all his fault. We didn't have to have medians here. But they never got that far, did they? They never got into the state's liability for bad design, improper signage.
No, I mean, we have to presume the jury did get into it and decided that 0% for the state and 100%.
No, they had some
You
sort of.
made all your arguments and presented all your evidence about the design.
They had special, they were supposed to go to a step 2 involving the state's possible liability for bad design. They never got there.
Because they found him 100% at fault. It was
Exactly,
all on
because
trial.
he's a marijuana junkie user, terrible person. And that's the way they painted him, deliberately did that.
Well, I mean,
Great tactic, but
let's
still.
kind of keep this in the realm of the record, right? I mean, no one polled the jury, and the jurors weren't coming out and saying, "Oh yeah, that druggie."
No, but
I
that's
didn't find that in there.
that's what they wanted. What other reason would you have for doing this when you know
What's your
it's
best
not
quote
relevant?
from the record where they said this horrible person, he's a bad junkie?
Gosh, I went through everything pretty closely at the in the brief. Statements that
You've used some, and I'm totally giving you that you've been using flowery language in the argument, but give me just one good example where they really what you would say is crossed the line in trying to tie this solely to marijuana use.
Well, you got an opening statement, for instance, and there's just instances. There's all right. State's lawyer stated one of the basic rules of driver safety is don't drive with marijuana in your system. And when drivers break these basic safety rules and cause a crash, the driver is responsible. You break the basic safety rule, no marijuana. And then she says, after the crash, his blood was tested positive for THC. He fell asleep. And in fact, his brother yelled, "Hey, hey, hey." He will say that he smoked a blunt that day. And our toxicologist will say that he had 3.2 nanograms per milliliter of THC in the system at the time of the blood draw. Then they ask a bunch of questions about it at trial from various witnesses.
Mr. Abney, I hear all of this is going towards whether or not a third party is at fault for what happened.
Right. But the reason you're at fault, that's what taints the whole process.
So you
Yeah.
can't talk about, what if we're not talking about marijuana? What if we're talking about DUI?
Well, I assume you're going to have a
Alcohol.
toxicologist brainy enough to say that alcohol certainly causes impairment.
Well, let
You
me
don't
ask
have
that's a
that
good
here,
question.
though.
That's a good, let's say you have alcohol, but not the DUI level. But you test and
Impaired to the slightest degree.
and sure enough, there's alcohol in there. And you find beer cans littered throughout
Yeah.
the car, and maybe a little dribble of beer on his chin.
Yes, Your Honor.
In that situation, could the evidence of alcohol come in?
If you have an expert witness to say that based upon the level that was tested at such and such a time by retrograde analysis, which you can't do in this marijuana kind of thing, then this person was impaired to the slightest degree. Or maybe was significantly impaired, or maybe was falling down drunk and totally incapable of competent driving. You'd have to have that expert testimony. You don't have it here. All they're doing by bringing marijuana in is to say that Behar is a bad person.
Wait a second. So what you just, maybe I misunderstood. I'm sorry. I don't want to put words in your mouth. But what I understood what you said is that if there's no expert, and if this guy is falling down drunk and absolutely 3 sheets to the wind, if they don't have an expert there, then the jury can't, using that evidence, which is not contested, the jury cannot say this guy was impaired.
No, I
You
don't
need
think-
the expert to say he was impaired.
No, I hope I didn't say it that way. I think the expert could say, based on retrograde analysis, he must have been
Well, let's assume there
incredibly impaired.
isn't an expert.
Get rid of the
because
expert.
That's what we're talking about.
But if you
There-
get rid of the expert and you say the trooper on the scene says, he fell out of his car. He couldn't walk a straight line. He flunked every field sobriety test known to man. And he had alcohol in his breath. His eyes were bloodshot. He was crying. He was incoherent. His face was flushed. In my opinion, as an expert trooper, he was clearly impaired by alcohol.
I thought we had cases that said lay, and this is in drunkenness and alcohol, which we're getting kind of a field here on, but I thought we had opinions that say you can offer lay opinion that someone appeared to be drunk.
You may be able to do that, sure.
Yeah.
I mean,
You
we
don't need
can,
an expert.
I was just trying to make it as
Yeah.
strong as possible by
Did-
mentioning a trooper.
Didn't the officer smell marijuana?
I think he did. I mean,
Okay.
that's stench. I was in the Navy. I had guys that used to smoke marijuana. I've never used it in my life, by the way, never. I've had, my roommates were constantly smoking. It was a bad time in the Navy. And it stunk like crazy and hung around for a long time. But that doesn't matter. The only reason to bring the marijuana in was to make Behar a bad person out to the jury. And so the jury would be swayed to say, okay, look.
Well, I agree with you that they use the marijuana. I still don't know, and what you described earlier is arguing that marijuana was a contributing factor to this.
Right.
I'm still, where's this that made him out to be a bad person? That's the example I'm looking for, that they were really just trying to go beyond reasonable inferences. So
If
to
you
speak.
deliberately use a drug in an illegal way, apparently his marijuana card, health card had expired. So if you were using a drug in an illegal way or using an illegal drug, however you want to frame that, and that contributes to you falling asleep and causing a terrible accident, you're not only a bad person for causing an accident, you're just a bad person for putting yourself in that situation.
I agree.
And that's not good.
But is there a good example that you can point to in either their argument or testimony that where they were kind of crossing that line from like marijuana's involved to saying this is a bad person, punish him, not us?
Huh. They didn't. No, I don't think they actually said this is a bad person, but they did it in so many words.
Did they use
He
the
smoked
word
a blunt. He smoked a,
junkie, druggy, things
well,
like that?
he smoked a blunt. It's illegal. Let's see. What else did they say? Hold on a second.
And you have 4 minutes and 45 seconds if you want to get to after this,
Okay.
the other issues.
Well, and this.
I don't mean to put you on the spot. Mr.
Well, no,
Remy.
it's-
You were-
I don't-
You were earlier were saying. kind
It's
of
much nicer than last
descriptive
argument. I'm
terms.
happy to be answering these questions. My opening brief, page 44, it quotes the stuff about Behar and you know. And they say, this is the thing you say to the trooper after DUI, just had 2 beers, officer, just had 2 beers, and he smoked a blunt. He knows it's not the thing to do. And yeah, the whole thing is to paint him as a marijuana user. It's not relevant in the slightest. And yet they did it over and over. And the only reason they did it was to make sure that the jury would blame Behar and just load fault onto him so there wouldn't be any fault against the state.
So I just want to make sure I understand your argument. What if they never used an adjective to describe him in a bad light? Would there still be error?
If they had never raised marijuana in any way.
No. Just said it's, junkie or just an adjective to characterize it as an evil person.
Even if they had been objectively dispassionate.
Okay.
It wouldn't matter because marijuana is utterly irrelevant. The only reason for raising it here is to paint him as a bad person, either dispassionately and objectively or subjectively by using as many words as you can, like blunt, that sort of thing, which I had to look up. Not a very nice thing. Anyway, I'd like to reserve my remaining time.
Okay. Ms. Weineke.
Thank you. May it please the court, counsel. My name is Kathleen Winicky, and I, along with my co-counsel, Mr. Ross, represent the state of Arizona. We were trial counsel as well. And I can assure you that at no time did we ever call Mr. Behar a druggie, a junkie, or characterize him as an evil person. The reason the marijuana evidence was asked for and approved by the trial court was because the state had named him as a non-party at fault, just as we had alleged Cynthia Casaus, because of her speeding at 84 miles per hour, were contributorily negligent and or comparatively at fault. But at no time did we ever argue to the jury that Mr. Behar's marijuana use absolved the state of Arizona in any way regarding the road design claims that were made against us.
Counsel, let me ask you a question, just a factual question. Can you explain to us the testing positive, and then there was 6 months later there was tested and it wasn't?
Yes, sir.
Tell us those facts.
The motor vehicle accident happened at 4:30 p.m. The blood draws were done by the hospital and by DPS pursuant to a search warrant. The hospital blood sample was BB sample. That was done at 6:51 p.m. The DPS blood draw pursuant to search warrant, the gray top tube, was done at 9:09 p.m. That was sample AA. The sample AA sample was tested on January 5th.
Okay.
That's
so-
the one that showed the presence of THC and carboxy.
So the 6:51 a.m.,
The 9:09 p.m.
the 9:09 p.m. returned metabolites, but the 6:51 didn't?
No,
AM?
sir. The 9:09 p.m. showed THC and carboxy, which was tested 2 weeks after the crash.
What about the 6:51? What did
That
show?
was tested 7 months later pursuant to the Navajo County Attorney's Office request. That only showed the presence of the non-impairing metabolite, and the explanation, possible explanations for that was it was a much smaller sample, and the county attorney letter that was provided to the plaintiffs and not to the state until after the trial, which is called the Navajo County Attorney Letter, was that possibly Mr. Behar had eaten marijuana, which is also referenced by the trooper's testimony about the green leafy materials found at the crash scene on his face. That's the evidence regarding the blood draws.
So you introduced evidence to show the jury that the test after 6 months isn't as effective or meaningful as the test immediately.
Not quite. We introduced the evidence of all the testing, which included the times of the draws, but we did not go into that with the trooper. Significantly, the plaintiffs never cross-examined the troopers regarding that information, never cross-examined our toxicologist, Dr. Smith, about that, and never called their own expert, Mr. Flaxmeyer, to talk about that. We think that is a material strategy on their part, which they're now complaining about.
Well, didn't they move, go ahead.
No, please.
Did they move to exclude evidence of marijuana based on that fact, the
No.
6 months?
No, sir. The motion in limine that they filed was to exclude the evidence of marijuana, and they provided no information to the trial court about that second test. In their motion for sanctions that they filed in conjunction with their motion for new trial, they alleged the state never produced that second test report, which the record is not in dispute that we produced it in our second disclosure statement in February of 2020, 3 years before the trial. And the trial court denied that motion for sanctions, finding that we did disclose that. What's significant is that neither toxicologist addressed that second sample. But I do want to...
Ms. Weinecke, if I
Yes.
can interrupt you here. One of the points that Mr. Abney made that I find most compelling, and I'm not speaking for the rest of the panel, is that your expert hemmed and hawed a little bit about whether there's any linkage. So how is any marijuana evidence relevant if it's only possible that it might have impacted Behar's driving?
Well, I would direct the court to the record, index of record 518, which recall that Dr. Smith's testimony was pre-recorded. He was out of the country, and so we took a trial deposition. And the trial court had that deposition transcript prior to ruling on the motions in limine. And the trial court made a specific finding based on a review, he had that preview, that there was sufficient evidence to deny the motion in limine. And then in ruling on the motion for a new trial said that Dr. Smith testified that he was impaired.
Okay, so you're describing what the trial court described Dr. Smith's testimony. Tell
Yes.
me what Dr. Smith said that says that there's some relevance to
Well, you will find that description in IR 518, starting in pages 38 through 41.
I'm sorry, 38 through 41?
Yes, sir.
Thank you.
And what Dr. Smith described was in part a research study that talked about that you can expect in a situation where you've just smoked or had marijuana and smoked it through a blunt, in this case, that they found that someone who might be impaired in an automobile crash, so they said 1.4 hour average decrease in the blood THC concentration was 90%. So what he was talking about was when you test it to 4 hours, that degradation of 90% from the time of the crash. So his opinion was, I think that the THC level at the time of the crash was actually much higher, as much
okay.
as 13 nanogram per milliliter.
I'm with you that the differences between the two tests, those are all jury questions. What I'm asking for is what evidence did you present that some nano metabolite, some rating causes impairment?
He testified that you have a slower reaction time when you're on THC, and that there was no evidence of braking as he traveled through the median, and because of the THC, that would impair his ability to brake. He relied on that. He also testified, in general, sleepiness can be a result of THC, or it can be just being distracted. He gave both of those options. And then this question at page 53. Doctor, do you have an opinion whether the time of the crash Mr. Behar was driving a vehicle while there was THC or its metabolite in his body? Answer, yes. And what is that opinion? He did have those things in his body. Now remember,
I'm with you on that. I'm still looking for your best example. You've talked generally about sleepiness. Where
Well-
is something that I can look at and say, he opined that the presence of metabolite, even though it's disputed, or the consumption of marijuana, by his own admissions of smoking the blunt, et cetera, lets us believe that it's probable that that impacted his driving.
well, first, he just said, the passage that I read said he had the THC in his body at the time of the crash.
Okay.
But then.
Stop talking about the presence. I'm with you on the presence. Now talk about the effect of that.
Sure. And the reason I'm talking about the presence is because.
I know, but I kept saying we're past that, so let's go on.
All right. And we have to show impairment to the slightest degree. He talked about going through the median without any braking, and he talked about that as being evidence of the impairing effect, slightest degree.
Okay.
You said he said there's a slow reaction time?
Yes, it decreases your reaction
Would
time.
that be an answer to Judge Morse's question?
That's correct.
And
He said,
possibility of sleepiness, even though there are other possible explanations for it, sleepiness is associated with marijuana.
exactly, and that's what he testified to. He
He
wasn't.
just said, I can't say for certain that it's this or this, but I do know that marijuana is associated with sleepiness.
That was his testimony, because he had also started out earlier in California and had driven 6 hours. He didn't want to rule it out completely that he could have just been sleepy from the drive, but he also said sleepiness is an impairing effect from the use of marijuana.
Sleepiness to fall asleep on the roadway at 4-something p.m.
Correct, correct. He also talked about all of the paraphernalia that was in the car, the mason jars of marijuana, the baggies of marijuana, the leafy material on his face.
Although the jury didn't rule on that basis, did it?
Well, and that's another point that I think is vitally important in this case. We have to presume that the jury followed the instructions, and the instructions that were given provided them a roadmap as to what to do. It's our position, and in support of this verdict, that the jury never got to Mr. Behar's fault. And we reach that conclusion by looking at what's based on Raji 8, which is the instruction regarding comparative fault, which tells the jury that if you find the state was not at fault, then your verdict must be for the state. If you find that the state was at fault, then the state is liable to plaintiffs and your verdict must be for plaintiffs. You should then consider the state's claim that Cynthia Casaus was at fault and the state's claim that Giovanni Avila Behar was at fault. This roadmap is extremely important because once the jury declared that the state was not at fault, they were done. They need then go to the verdict form that was applicable, which is verdict form number 3. That verdict form is also imperatively important because verdict number 3 said, we, the jury, find the state of Arizona in favor of the state of Arizona, and then it had a very important line at the bottom, and that very important line in the verdict form is index of record 575, and that said, if you fill out this verdict, form 3, stop. And that's what they did.
So if we presume that the jury follows its instructions, which our Supreme Court has told us we're supposed to do, then they actually didn't even get to Mr. Behar's
comparative fault. All they did was say that
There shouldn't have been. a
plaintiff had
median
failed
divided,
to show that it was negligent not to have a median there.
Absolutely.
So maybe marijuana shouldn't have been admitted.
No, because at that point, we don't know what the jury was going to do, and it's our burden of proof to show the non-party at fault's fault. It's also our burden not to prove that Mr. Behar was at fault, but what is the degree of fault? For example, if Mr. Behar had a tire blow and he had no notice of the tire, the jury might think, well, maybe you were negligent, but maybe it's 1-2%. But what if he had been driving on bad tires for 2-3 months, and the mechanic had said, those are really bad tires, you need to get them fixed? He's like, I'm not going to worry about it. I'm going to take off on this road trip to Arizona, and he put the public at risk. That evidence would be admissible for the jury to assess the degree of his fault. The marijuana is in that same category. If he fell asleep because he was too tired and he crossed that median, that would be some percentage of fault. But if he also was taking drugs, which are known to be illegal, that would entitle us to the presumption, the 28-13-81, impaired to the slightest degree, which is negligence per se, and that's based on negligence 2A and negligence 1, which we can get in tandem, according to the Rajis. That helps the jury find negligence per se, and then assess a higher degree of percentage of fault. So I completely disagree with my esteemed counsel that it's not relevant. It's absolutely relevant to Mr. Behar's fault. I also want to correct the record. In the plaintiff's brief at page 9, he attributes statements made to the state erroneously. It's a quotation from the closing argument. This is in the reply brief, in which plaintiffs claim that the state abandoned their claim of Cynthia Casaus' negligence. These are the statements of the plaintiff's counsel. Really, really important. At the bottom of page 9 in the reply brief, the plaintiffs state, the state's lawyer conceded that, and then it includes a block quote. Those are not our words. Those are the words of the plaintiff's counsel. In fact, the state argued Cynthia Casaus was at fault for going 84 miles per hour, and she said she did that because she thought the road was safe. We even showed a deposition clip of that in our opening statement. So I just want to make sure that record is clear. I would like to just move on to the issue of duty, unless the court has any more questions about the marijuana. I'd like to address the issue of duty, because in this court, in this case, the trial court gave an instruction on duty based on the language in Glazer. Plaintiffs claim that that was error because the failure to include certain language, what they claim is based on Bach versus State. That was contained in non-Raji 1. We would suggest that they conceded that non-Raji 1 should not be given, and that's in the record. They said that they're really more concerned about was non-Raji 2, which includes that foreseeability language. It's our position that after Gibson, that inclusion of that foreseeability language no longer survives. As Gibson made clear, and as well as the Kieras versus Alcoa case, that we no longer look at the definition of duty with the foreseeability of risk language. And the courts have made clear that that is not the appropriate way to describe duty. Even if plaintiff doesn't concede that they agreed to the court's instruction and they still wanted that language in non-Raji 1, that additional language was describing the duty to include the installation of barriers, guards, rails. It's our contention that the Glazer language, which cites to Bach and leaves out that additional language, was the appropriate thing to do in this case. The reason why the trial court rejected that was because in a case where the plaintiff is saying you need to put in a median barrier, and the state is saying our guidelines, our standards, the ADOT roadside design guide does not require it. If the court were to give that instruction, it would be putting a thumb on the scale in favor of the plaintiff, because the duty would be described as you got to put it in, and we wouldn't be starting on the 50-yard line.
Are there legitimate reasons for not putting a median barrier in between to divide highway lane?
Yes, sir. The evidence that the state presented.
Other than lack of resources to put barriers everywhere.
Sure, and that was not one of the reasons that the state provided at trial. The evidence here on I-40 at milepost 276, despite the fact
What's the
that
nearest town for that?
it is, there is a rest stop there, but Joseph City, I think. It's right on towards the New Mexico border. And the plaintiffs were on their way to, or back from New Mexico, where they have family. The reason is, and it's a great question because it is not typically known, but a cross-median crash is one in which a vehicle crosses over from one side over the median and hits another vehicle. That's Arizona's definition. And despite the characterization that this was a very dangerous road with lots of cross-median crashes, 59 million cars passed through this area in the 5 years prior, and only one vehicle crossed the median and hit another vehicle. The
Prior
court,
to this one, or?
prior to this one.
Okay.
The court let in 11 prior crashes. Only one was a cross-median crash. The rest were single vehicles that went through. We have 84 feet of a wide open median, and the research shows give people space that allows them to go into the median and recover before going to the other side. If you put a median barrier there, people are going to hit that barrier, and that could cause more or greater injury than if you gave them that space to recover. And that's the trade-off and the balance of risks. And so
All that
Arizona,
evidence was presented to the jury?
absolutely, the bulk of this case was about those guidelines, and the court allowed the plaintiff to bring in guidelines from Wisconsin and Florida and California over our objection because we followed Arizona's guidelines. And that was the majority of what we spent our time on. The issue of Behar was a small fraction of the case.
Something like most people stop within 30 feet. After
Exactly.
the roadway
And that our expert put on evidence that you have a 100 times greater chance of being struck by lightning than getting in a cross-median crash, and that you have a greater risk of harm if you were to install a median barrier. This is kind of heavy.
Not harm to the people who don't cross, but harm to the people who do.
Right.
Well, actually, isn't it? That,
Well,
I thought I was reading that it could have turned all the one car
into a real crash, right.
into a fatality.
Right, right. And we did that through scientific research, which researched the probability of crashes. And Arizona has a very conservative, while most states say put in a median barrier if it's 50 feet, we mandate a barrier at 78 feet. So that's what the case was about. And so the verdict was in favor of the state because the plaintiffs did not prove we violated the standard of care. Unless the court has any questions about the other issues in the brief, I'm happy to answer those. But with that, I respectfully request that the court uphold the verdict in favor of the state. Thank you kindly.
Thank you, Ms. Winicky. Mr. Abney.
My colleague made a point of saying that the jury followed the instructions. We're supposed to presume the jury followed the instructions. Well, one of the instructions that the state insisted the trial court provide to the jury and was reckless driving. And they did that because reckless driving tied in with marijuana. And the instruction was that it's unlawful for a person to drive or be in actual physical control of a vehicle while under the influence of marijuana or its impairing metabolite. A person is considered to be driving under the influence of marijuana or its impairing metabolite if his control of a vehicle is impaired to the slightest degree. And so that's the ultimate tie-in to the marijuana use. You get a specific jury instruction. You find this guy is not just a bad driver in general because he fell asleep, but you also find that he is committed reckless driving because of marijuana. But there was never any scientific evidence that he was impaired in any way by marijuana, simply that there was
Mr. Abney,
marijuana around.
I'm somewhat intrigued by the logic that the jury never gets to the marijuana question because it says that the state wasn't negligent, period.
Well, never.
The state's not at fault, so you don't apportion fault because the state is not at fault.
Well, and the jury
That
could have easily decided by reading those instructions, okay, we know who's at fault. We know the state
Instructions
is not
tell
at
them
fault.
Specifically how to answer the forms, and so the form they filled out
Right.
says, we find the state's not at fault.
Right.
Not, we find Mr. Behar is 100% at fault.
Well, you ask the jury, is the state at fault? No. And why? If you could probe into their minds, into the minds that have been constantly bombarded with marijuana use, of course the state's not at fault. Behar, the junkie's at fault.
Junkie.
So why would we ever say the state's at fault? We would say, no, state's not at fault. We know who's at fault. Behar. How much is he at fault? He's 100% at
But
fault.
the instructions told them how to answer it this way. So
Right.
if they had wanted to say Behar was 100% at fault, there was forms and instructions that told them how to get there.
But the form they used is completely consistent with the theory that they were blaming Behar
Form- The
100%.
instruction told them how to answer this.
Right.
form.
And if you read that instruction, is the state at fault? No. But why is the state not at fault? Not got anything to do with design. We know who's at fault. Behar's at fault.
But, was your colleague wrong that most of the jury trial was spent arguing about whether it was negligent not to have a barrier here?
There was a lot about that, a whole bunch about that. But it didn't matter, did it?
And
Behar's
what
at
can
fault.
you point to say that, no, the jury actually disregarded all that and only relied on
Well,
the marijuana use?
we'll never know for certain, but we do know the jury was poisoned by irrelevant
How do we
prejudicial
know that
evidence.
the jury was poisoned?
Well, isn't it a presumption if you present a jury with poisoned prejudicial evidence that there's going to be some sort of prejudice from it?
I don't think so.
I don't know how you
I
could
think
not.
we find that there's harmless error all the time based upon evidence that was presented that was irrelevant.
Well, this is,
You have, the burden is on you to show that that actually impacted the jury's verdict, and I'm wondering what you can point to say that it did.
well, all we can say is that from voir dire through opening statement, through the presentation of evidence to closing statement, the drumbeat was Behar's at fault because of marijuana use. He was impaired. He's a reckless driver. And because he's a reckless driver, he caused this collision. He caused this collision.
Thank you, Mr. Adams.
Thank you, Your Honor.
We thank counsel for your arguments. We will take this matter under advisement and issue a decision in due course. The court is adjourned.